Most people imagine federal law enforcement as a handful of famous badges: the FBI, the Secret Service, maybe the DEA. In practice, the system is far larger and far more specialized. It is not one force. It is a distributed enforcement architecture made up of investigative bureaus, border agencies, protective details, inspector general offices, land management police, military criminal investigators, and regulators with arrest powers. What looks from the outside like a single machine is really a network of missions, each built around a different legal authority, operating environment, and national priority. At the center of that network sit broad agencies with sweeping mandates. The FBI functions as the federal government's principal domestic investigative and intelligence service, handling everything from counterterrorism and counterintelligence to cybercrime, corruption, organized crime, and major financial fraud. Around it are narrower but highly focused institutions. The DEA concentrates on controlled substances and trafficking networks. ATF works the firearms, explosives, arson, and diversion space. The Marshals Service protects the federal courts and hunts fugitives. The Secret Service protects leaders while also defending the financial system from counterfeiting and cyber-enabled fraud. But the system extends far beyond the agencies most citizens can name. CBP controls the physical border and ports of entry. ICE pushes immigration and customs enforcement into the country's interior. IRS criminal investigation follows illicit money. Postal inspectors police crimes that move through the mail. Diplomatic security protects embassies worldwide. Air marshals operate inside the aviation system. Military investigative services police the armed forces, while agencies like EPA, Fish and Wildlife, NOAA, and the Forest Service enforce laws tied to resources, land, and environmental harm. That is the real picture, not a single federal police force, but a layered structure built to enforce very different laws in very different spaces. To understand how this apparatus actually works, the first question is not who has the most famous name. It is how the government divides jurisdiction, because jurisdiction is what turns a collection of agencies into an operating system. To understand how this system functions, the first thing to examine is jurisdiction. Federal law enforcement is not organized around a single national police chain. It is organized around legal boundaries. Every agency exists because Congress assigned it a mission, a set of statutes, and a zone of responsibility. That is what determines who can investigate a case, who can make an arrest, who can carry it across state lines, and who must step aside when another office has the stronger claim. That sounds technical, but it shapes everything. The FBI can pursue a public corruption case with national implications. DEA can dismantle a narcotics network that crosses borders. ATF can trace illegal firearms trafficking and explosives violations. Postal inspectors can step in when the mail system is used to facilitate fraud or transport contraband. IRS criminal investigation can build a case by following money that other agencies first detected through violence, drugs, or cybercrime. Often, the same criminal enterprise triggers multiple federal interests at once. That overlap is not a flaw. It is part of the design. Modern cases rarely fit neatly into one category. A cartel route can become an immigration matter, a financial laundering matter, a border security matter, and a firearms matter at the same time. In those situations, jurisdiction becomes a coordinating tool. Agencies form task forces, share intelligence, divide targets, and decide which statute gives prosecutors the strongest path. The goal is not to preserve clean organizational lines. It is to convert legal complexity into operational leverage. A major historical shift accelerated this model. As threats became more networked, especially after the expansion of counterterrorism, cyber investigations, and transnational organized crime cases, federal enforcement moved further toward joint operations. The badge on the vest still matters, but the case increasingly belongs to a multi-agency structure. And once jurisdiction defines who is in the room, the next question becomes even more important. Who actually gives the orders, and how does that chain of command hold such a fragmented system together? There is no single commander of all federal law enforcement. That is one of the most important things to understand. The system looks unified from the outside because agencies wear federal insignia and enforce federal law, but in practice, authority is distributed across departments, bureaus, U.S. attorneys, and the Attorney General's broader policy framework. What holds it together is not one national police chief. It is a layered chain of command built through law, bureaucracy, and prosecutorial control. Inside each agency, the structure is clear. Headquarters sets doctrine, priorities, and national programs. Field officers translate that guidance into regional operations. Resident officers, task force groups, border sectors, ports of entry, district commands, and specialized teams handle the actual ground-level work. The FBI runs through headquarters divisions and field offices. DEA relies on domestic divisions and overseas offices. CBP breaks authority across sectors, stations, and ports. The U.S. Marshal Service organizes through districts tied to the federal court system. Each structure reflects mission. Intelligence-heavy agencies centralize analysis, while patrol-heavy agencies push authority outward. But chain of command does not stop inside the agency. Federal prosecutors play a defining role. In major criminal investigations, agents may build the case, but U.S. attorneys and the Department of Justice determine charging strategy, legal thresholds, and courtroom direction. That means operational momentum is constantly shaped by what can actually be proved, indicted, and sustained in federal court. In effect, federal law enforcement answers not just upward through administrators, but forward into the prosecution process. Large national events reveal how this works in practice. After major terrorist threats or complex interstate manhunts, multiple agencies can operate simultaneously under joint command arrangements, with one lead agency taking point, while others provide intelligence, surveillance, logistics, or tactical support. Coordination centers, fusion cells, and task force command posts help convert fragmented authority into a workable hierarchy. So the chain of command is real, but it is conditional. It shifts by statute, case type, and operational lead. And for that system to function under pressure, it depends on something even more basic than hierarchy: money. Because funding decides what kind of federal power can actually be sustained. To understand what federal law enforcement can actually do, it is necessary to look at funding. Jurisdiction defines responsibility, and hierarchy defines authority, but budgets determine capacity. An agency may have broad legal powers on paper, yet its real reach depends on how many agents it can hire, how much technology it can deploy, how many officers it can sustain, and how long it can keep complex investigations running. In that sense, appropriations are not background administration. They are operational design. The contrast across agencies is striking. Large organizations like the FBI, CBP, and ICE operate with massive institutional footprints because their missions require national infrastructure: field offices, laboratories, data systems, training centers, aircraft, detention capacity, or large-scale border operations. Smaller agencies often have narrower mandates and far fewer personnel, but that does not make them minor. IRS criminal investigation, postal inspection, diplomatic security, and agency-specific inspector general officers can exert outsized influence by focusing on specialized cases where technical expertise matters more than headcount. Funding also shapes behavior. Agencies with patrol and screening missions spend heavily on personnel, equipment, facilities, and logistics. Investigative agencies devote more resources to surveillance platforms, forensic tools, intelligence analysis, confidential informant programs, and long-duration casework. Protective missions require travel budgets, secure communications, and advanced planning teams. Financial crime and cyber work demand analysts, software, and highly trained specialists who can translate data into evidence. A clear real-world shift emerged after the attacks of September 11th and the broader rise of cyber threats. Federal dollars moved heavily toward homeland security, intelligence integration, aviation security, border enforcement, and digital investigative capacity. That did not eliminate traditional crimes, but it changed institutional emphasis. Resources followed the threats that Washington judged most strategically urgent. That is why budget lines matter so much. They reveal what the government fears, what it prioritizes, and what kinds of cases it expects to fight in the future. But money alone does not create federal power. To turn appropriations into real capability, agencies need people who can operate under that system, which means the next layer is training. Federal agencies do not simply hire law enforcement officers and send them into the field. They build personnel through long pipelines of screening, academy instruction, legal education, firearms qualification, defensive tactics, report writing, and mission-specific specialization. That matters because federal enforcement is less about visible patrol presence than about operating inside a legal and bureaucratic system where a poorly written affidavit, an improperly handled search, or a broken evidence chain can damage an entire case. Most federal officers and agents begin with a common foundation. Basic training covers constitutional law, arrest authority, search and seizure rules, use of force standards, interviewing techniques, surveillance awareness, and courtroom procedure. Many personnel pass through federal training environments that standardize these fundamentals across agencies. From there, the tracks diverge. A border officer needs inspection authorities and port procedures. A criminal investigator needs case management, source handling, and warrant preparation. A protective agent needs advanced planning, threat assessment, and movement security. A financial investigator may spend more time mastering records, shell companies, and digital tracing than practicing dynamic entry. This specialization is what turns federal law enforcement into a technical profession rather than a generic policing model. An IRS CI investigator has to understand forensic accounting. A postal inspector may need deep familiarity with fraud schemes and mail-based evidence. ATF personnel may train around firearms tracing, explosives, and arson reconstruction. FBI agents can be pushed toward counterintelligence, cyber, public corruption, or crisis response, depending on assignment. The badge may look standardized. The expertise is not. A major operational lesson over time has been that modern threats evolve faster than traditional training cycles. Cybercrime, encrypted communications, drone activity, synthetic identities, and transnational money movement have forced agencies to retrain constantly, not just at the academy, but throughout a career. Initial instruction, creates a federal officer. Continuous adaptation keeps that officer relevant. And once personnel are trained, the next challenge is where to place them, because federal capability depends not just on skill, but on how that skill is distributed across the country and beyond it. A federal agency is only as effective as its footprint. Training creates capability, but deployment determines whether that capability reaches the problem in time. This is why federal law enforcement is built around a dispersed field structure. Headquarters may set national priorities, but real enforcement depends on field officers, resident agencies, border sectors, ports of entry, district commands, attaché posts, and task force placements that push federal authority into specific regions and specific operational environments. That geography is not random. It reflects where the mission actually lives. CBP concentrates personnel at land borders, airports, and seaports because its work begins where people and goods enter the country. The Marshals Service aligns much of its structure with the federal courts because prisoner movement, judicial protection, and fugitive operations are tied to that system. The FBI and DEA maintain broad field networks because threats like organized crime, corruption, cybercrime, and trafficking do not remain inside one city. Diplomatic security extends outward through embassies and consulates because federal protection responsibilities do not stop at U.S. territory. This distribution creates a practical advantage. Local presence allows agencies to build sources, understand regional criminal patterns, coordinate with state and local departments, and respond faster when a case develops. A smuggling corridor in Arizona does not look like a financial fraud hub in New York or a cyber intrusion case linked to servers overseas. Federal deployment has to reflect those differences. The same legal authority exists nationwide, but the operational posture changes by terrain, infrastructure, and threat profile. A major shift in recent decades has been the expansion of joint placements. Rather than relying only on standalone federal offices, agencies increasingly embed personnel in task forces, fusion environments, and interagency centers. That allows intelligence, investigators, prosecutors, and tactical teams to operate closer to the same problem set from the beginning. Because once personnel are in the right places, the next question is not where they are, it is what they know. And that moves the system into its most important currency, intelligence. Federal law enforcement runs on intelligence long before it runs on arrests. Agents and officers do not simply wait for a crime to appear in front of them. They build pictures of networks, routines, vulnerabilities, and intent. That can mean human sources, financial records, surveillance, travel patterns, communications metadata obtained through legal process, open source research, interagency databases, or tips from foreign and local partners. The objective is not just to know what happened. It is to understand how a system operates before it fully reveals itself. This is where major differences appear between agencies. The FBI integrates intelligence and investigation more directly than most traditional police organizations because national security cases often depend on detecting patterns before a prosecutable crime fully matures. DEA maps trafficking routes, cartel logistics, and distribution cells. CBP and ICE collect data tied to movement across borders, cargo flows, and immigration records. IRS criminal investigation turns financial documentation into an intelligence picture of hidden ownership, laundering channels, and illicit revenue streams. Postal inspectors can identify fraud ecosystems by following mailing behaviors that look ordinary in isolation but revealing at scale. A real operational lesson from the post-9/11 era was that information scattered across agencies is far less valuable than information fused into one working picture. That is why the federal system expanded joint terrorism task forces, watchlisting structures, fusion centers, and interagency analytical units. The aim was to reduce blind spots created when one agency knows part of a story and another agency knows the rest. Intelligence became less about ownership and more about integration. But intelligence only matters if it survives legal scrutiny. Raw information is not automatically evidence, and suspicion is not automatically action. Federal agencies have to translate fragmented clues into affidavits, warrants, interviews, subpoenas, and prosecutable case files. That is the pivot point in the system. Once intelligence identifies a target or network, the next layer is the investigative machinery that turns knowledge into enforcement power. Once a target is identified, federal law enforcement shifts from intelligence collection to case construction. This is where the system becomes procedural. Investigators have to convert suspicions, fragments, and analytical leads into a legally defensible sequence of steps: interviews, subpoenas, search warrants, undercover activity, surveillance requests, forensic examinations, document seizures, and coordinated arrests. The federal case is not built around speed alone. It is built around durability. That requirement shapes the way investigations are run. Agents document everything. Evidence has to be collected, logged, preserved, and explained in a form that prosecutors can use and defense attorneys cannot easily dismantle. A complex case may involve months or years of records analysis, source development, grand jury process, and interagency coordination before the public sees any action at all. What appears from the outside as a sudden raid or indictment is often the visible endpoint of a long administrative and legal buildup. Different agencies bring different investigative strengths into that process. The FBI may handle multi-subject conspiracies involving national security, public corruption, or organized crime. DEA can build layered narcotics cases from street distribution up to transnational command structures. ATF focuses on firearms trafficking, explosives, and arson evidence. IRSCI often becomes decisive when financial documentation provides the clearest path to proving a broader criminal enterprise. In many cases, prosecutors choose the charge not because it is the most dramatic allegation, but because it is the most provable federal violation. Major organized crime and corruption cases show how this works in practice. Investigators often do not begin with the highest-ranking figure. They build upward through records, cooperating witnesses, communications, and financial leverage until the structure of the organization becomes prosecutable. The method is cumulative. Each warrant, interview, or seizure is designed to strengthen the next move. But even the strongest case file remains incomplete without specialized support. To sustain modern investigations at scale, agencies need laboratories, analysts, surveillance platforms, and technical systems. In other words, they need technology. Modern federal law enforcement is not powered by manpower alone. It is amplified by technical infrastructure. Once investigations grow beyond simple interviews and physical surveillance, agencies rely on forensic laboratories, biometric systems, encrypted communications tools, data analysis platforms, license plate readers, cyber forensics, financial tracing software, and specialized evidence recovery capabilities. Technology does not replace the investigator. It expands the investigator's range. The form that technology takes depends on mission. FBI laboratories and digital forensics units help process everything from DNA and fingerprints to mobile devices and malware. ATF uses tracing systems and forensic analysis to connect firearms, shell casings, explosives components, and arson scenes to broader criminal patterns. CBP relies on screening systems, inspection technologies, and data tools that help officers identify risks in cargo, travel, and border movement. Secret Service and IRSCI increasingly operate in environments where financial crime, cyber intrusion, and digital fraud overlap, which means technical expertise can be as important as traditional fieldcraft. A major institutional shift occurred when federal enforcement moved from paper-heavy casework into data-rich investigation. In earlier decades, following a criminal enterprise often meant human surveillance, wire communications, and bank records gathered slowly over time. Today, investigators may confront cloud storage, cryptocurrency flows, burner devices, cross-platform fraud, and international digital infrastructure. That has forced agencies to invest in cyber squads, forensic examiners, technical surveillance specialists, and analysts who can turn huge data volumes into evidence that a jury can understand. But technology also creates constraints. Federal agencies still need warrants, legal process, evidentiary standards, and trained personnel capable of explaining complex systems in court. A sophisticated tool is only useful if its output can survive judicial scrutiny and be translated into a coherent narrative of criminal conduct. That is why technical capability is not the endpoint. It is an enabler. Once agencies have intelligence, investigators, and technological reach, they still need a way to project force safely when a case requires direct action. That brings the system to its most visible layer: tactical operations and enforcement on the ground. This is the layer most people picture when they hear the words federal agent: the arrest team, the raid, the convoy, the warrant service. But tactical action is only a small visible fraction of the federal system. It is the execution phase, not the core function. By the time agents breach a door, intercept a suspect, or move to secure a courthouse, a much larger structure of legal review, intelligence preparation, surveillance, and logistical planning has usually already done most of the work. Federal tactical operations vary widely by mission. The U.S. Marshals Service handles fugitive apprehension and judicial security, often working in high-risk environments where the target is mobile, armed, or already known to evade capture. The FBI deploys specialized tactical teams for hostage rescue, high-risk arrests, and counterterrorism support. CBP and ICE conduct field operations tied to border enforcement, smuggling, and removal actions. Protective missions, like those carried out by the Secret Service, emphasize controlled movement, perimeter management, and rapid reaction rather than traditional raid structure. Different agencies use force differently because they are solving different operational problems. Planning is what makes these actions viable. Teams have to assess the target location, legal authority, likely resistance, nearby civilians, medical contingencies, communications, and evidence preservation requirements. A warrant service is not just an entry problem. It is a coordination problem involving investigators, tactical personnel, prosecutors, transport arrangements, digital evidence recovery, and post-arrest interviews. Every mistake at this stage can damage both safety and the case itself. A major lesson from years of counterterrorism, fugitive operations, and organized crime enforcement is that federal tactical units are most effective when used selectively. Their value lies in precision, not spectacle. They exist to control risk at the moment when an investigation turns physical. But even a successful operation does not finish the federal process. An arrest is only the handoff point. After force has been projected, the system moves into the arena that ultimately decides whether the operation mattered at all. Federal court and prosecution. Federal law enforcement does not end with arrest. In many ways, arrest is the easiest part to see and the hardest part to sustain. What determines whether a federal operation actually succeeds is prosecution. The federal system is built to move cases into court with a level of documentation, evidentiary control, and statutory precision that can survive months of motions, hearings, and adversarial review. That is why investigators spend so much time building records before they act. The relationship between agents and prosecutors is central here. Federal agents generate facts, conduct interviews, execute warrants, and assemble evidence. But U.S. attorneys decide how those facts are translated into charges, what statutes provide the strongest path, whether cooperation agreements make strategic sense, and how a case should be presented to a grand jury or trial jury. That makes prosecution more than a legal afterthought. It is a command layer that shapes investigative decisions from the beginning. This is also where the distinct strengths of federal law become visible. Prosecutors can use conspiracy statutes, racketeering tools, firearms counts, fraud provisions, money laundering laws, immigration offenses, tax violations, and other specialized charges to pressure a criminal structure from multiple angles. In practice, a case is often charged through the most reliable legal route rather than the most publicly dramatic one. A network suspected of violent or transnational conduct may ultimately be weakened through finance, trafficking, document fraud, or obstruction charges, because those are cleaner to prove. Historical organized crime and public corruption cases illustrate the pattern. Prosecutors and agents rarely depend on a single event. They stack cooperating witnesses, surveillance, records, digital evidence, and financial documentation until the organization's internal logic becomes legible in court. The federal courtroom is where hidden systems are translated into official narrative, and that matters because the courtroom does more than punish individuals. It can dismantle organizations, seize assets, impose deterrence, and reshape criminal behavior. But enforcement still does not stop at conviction. To understand the full architecture, the next layer is what happens after judgment: detention, transport, witness protection, and the long federal afterlife of a case. A federal case does not end when a sentence is announced. Conviction is only one transition point in a much longer enforcement chain. After judgment, the system shifts into custody, transport, witness management, asset seizure, appeals support, and long-term supervision. This part is less visible than the raid or the trial, but it is what gives federal law enforcement continuity. Without it, even successful investigations would produce only temporary disruption. The U.S. Marshals Service sits at the center of much of this afterlife. It manages fugitive operations, prisoner transport, judicial security, and the witness security program, linking the investigative phase to the court system and the custodial process that follows. The Bureau of Prisons then takes over the long-term detention framework for sentenced individuals in federal custody. Other agencies remain involved as needed, especially when appeals, new evidence, cooperating witnesses, international extradition issues, or post-conviction asset recovery continue to generate work. Asset forfeiture is one of the most significant tools in this stage. Federal cases often target not just people, but infrastructure, bank accounts, vehicles, real estate, contraband, shell companies, and revenue streams. In organized crime, fraud, narcotics, and corruption cases, removing assets can weaken an enterprise more effectively than a single arrest. The goal is not only punishment, it is degradation of the system that made the crime sustainable in the first place. Witness protection reveals the same logic from a different angle. When organized groups, cartels, gangs, or corruption networks are penetrated from the inside, the government has to preserve the value of that cooperation. Protection, relocation, and identity change become extensions of enforcement because insider testimony can reshape entire prosecutions long after the first arrests are made. This is what makes federal law enforcement different from a purely reactive model. It is built to carry cases forward across years, institutions, and consequences. And once that machinery can sustain outcomes over time, the next question becomes even larger: how this entire network adapts when the threats themselves become more international, digital, and politically complex. The most important change in federal law enforcement is that many of its hardest problems no longer fit neatly inside U.S. territory or traditional criminal categories. A narcotics network may depend on foreign producers, encrypted messaging, shell companies, commercial shipping, fraudulent travel documents, and domestic street distribution at the same time. A cyber fraud case may involve victims in multiple states, servers in multiple countries, and suspects who never physically enter the United States. The federal system has had to adapt from chasing isolated offenders to confronting cross-border systems. That shift has changed how agencies operate. Federal law enforcement now depends far more on international liaison work, legal attaché offices, extradition processes, customs partnerships, sanctions enforcement, intelligence sharing, and joint investigations with foreign counterparts. DEA, FBI, Homeland Security investigations, diplomatic security, and other agencies increasingly function in an environment where information from overseas can be as important as evidence gathered in a U.S. city. The border is still a critical enforcement line, but it is no longer the only meaningful one. The digital environment has intensified that transformation. Criminal markets can now move money, identities, instructions, and contraband logistics through platforms that are fast, encrypted, and globally distributed. Agencies that once focused primarily on physical evidence now have to interpret platform data, cryptocurrency trails, cloud storage, synthetic identities, and blended fraud ecosystems that combine cyber tools with old-fashioned coercion and theft. The result is a federal apparatus that must think like a network because the targets increasingly behave like networks. A major lesson of the past 2 decades is that adaptation cannot be limited to one bureau. No single agency can independently master border security, financial tracing, cyber forensics, foreign liaison, and domestic prosecution at once. That is why the federal model continues moving toward integrated task forces and hybrid expertise. And that leads to the final question. Once all these layers are assembled, what is the actual strategic role of federal law enforcement in the broader American system, and what pressures will define its future? Federal law enforcement is often described as a collection of agencies. In practice, it operates more like a national control system for risk. Its role is not simply to arrest offenders after crimes occur. It is to identify threats that exceed local boundaries, coordinate legal authority across jurisdictions, protect critical institutions, and impose enough investigative and prosecutorial pressure to keep complex criminal and security problems from scaling unchecked. That is why the system stretches from border crossings and embassy compounds to federal courtrooms, cyber units, forensic labs, and witness protection. Seen from that perspective, its true function is strategic. Federal agencies are used where the stakes are national, interstate, international, financial, or institutional. They protect the continuity of government, the integrity of the border, the federal courts, the tax system, the mail, diplomatic facilities, public lands, and the infrastructure of interstate commerce. They also serve as the government's main mechanism for attacking organized systems of wrongdoing that smaller jurisdictions may not be built to dismantle alone. The visible badge matters less than the underlying purpose, concentrating specialized authority where complexity is highest. But that role is becoming harder to sustain. The future challenge is not a lack of jurisdiction or statutory power. It is the speed and scale of adaptation required. Criminal and hostile networks now exploit encryption, cross-border finance, synthetic identities, remote communications, and fragmented legal environments. At the same time, federal agencies face constant pressure to modernize technology, recruit technical talent, maintain civil liberties compliance, coordinate across bureaucratic boundaries, and justify expanding capabilities in a climate of public scrutiny. So the strategic reality is this: federal law enforcement is no longer just an enforcement apparatus. It is an evolving national infrastructure for managing complexity. Its success will depend on whether it can remain legally disciplined, technically current, and organizationally integrated while the systems it targets become faster, more decentralized, and harder to see. In the years ahead, that balance between power, precision, and adaptation will define what federal enforcement actually becomes.